welcome back from our stretch break. We are now going to discuss investment treaty challenges, and this panel is a very important one, which is evidenced at least by the fact that all our two sponsoring firms were interested in speaking on this particular panel, which means that it's of very high relevance to their practices. And so we both thank again Freshfields and Linklaters for sponsoring this panel. And Sylvia and Noury from Freshfields kindly agreed to moderate this panel. I had the pleasure to work with Sylvia at Freshfields before she became a partner, but I don't think we worked on any Africa-related cases. We have around 60 people who are now with us, and Sylvia, over to you. Please unmute yourself.
Thank you, Jarek, and good afternoon from the leafy suburbs of southwest London. Let me start by thanking the organisers at Bickel, Queen Mary and Babcock University for putting together such an excellent, truly excellent conference programme for this inaugural Africa Arbitration Day, and to say it's a real privilege for me to be chairing this very prestigious second panel today. I'll open this session by introducing our three panellists, as well as the topic for debate, which, as Jarek has said, is a discussion of some of the challenges that the African continent is facing relating to investment treaties and investor-state arbitration, or ISDS, as it's more commonly and catchily known these days. By way of programme, each of our panellists will offer their own perspective on this topic by way of a short presentation, following which I will open the floor to audience Q&A, and we will, as our other panel has done, really focus on the Q&A, so we'll keep the presentation short and hopefully have about half an hour for question time. Before I do proceed to introduce the panel, I'll perhaps make the trite observation that dealing with the challenges that ISDS presents is by no means an issue that is unique to Africa. Regional commentators speak of an emerging backlash against ISDS on the African continent, partly fueled by the termination by South Africa of its BIT some 5 years ago, and a variety of other initiatives relating to reform that we're seeing across the continent. But I should remark that this kind of backlash, if that is the right term for it, has really been a global phenomenon for quite some time now. And anyone who has worked in Latin America will recall the first outbreak of this backlash, which followed the wave of investment treaty claims against Argentina, Ecuador, and Venezuela all over 10 years ago. And closer to home, of course, we have our very own vocal backlash against ISDS right now going on in Europe. But it's also important to stress that the ISDS story in Africa is not just one of backlash. African states continue to sign BITs, including ISDS provisions. And while some states may be perceived to be taking a hostile approach to certain foreign investors, other states are rolling out the red carpet, including the offer of robust foreign investment protections and incentives. So the narrative is, of course, as with everything on the continent, a more nuanced one. What is certain is that ISDS has grown in prominence in the region in recent years. And in terms of exposure to ISDS claims, no one African state has been inundated with claims in the way that Argentina was a couple of decades ago, or in the way that Spain is today. But the closest is perhaps Egypt, which has racked up some 30 ICSID claims against it, although it should be remarked that this is over nearly 4 decades. Of course, the first claim against Egypt was brought back in 1984. The last ICSID publication focusing on Africa noted that by 2017, African states accounted for 22% of all respondents at ICSID. And while this is still less than the proportion of claims that have been brought against Latin American states, it should be seen that this percentage is increasing. In the last 3 years, for example, the percentage of new cases registered at ICSID against African states has averaged closer to 30%. Now, this perhaps explains why ISDS was selected as a key topic for today's conference, which brings me back to today's panel. And without further ado, let me introduce the panelists and allow them to illuminate us further on the subject of the challenges of ISDS in Africa. So I'll introduce the panelists in the order that they will present, starting with Ndanga Kamau. Ndanga is an international lawyer specializing in international dispute settlement and public international law. She is the founder of Ndanga Kamau Law, an international law practice based in The Hague in the Netherlands. Ndanga is a vice president of the ICC International Court of Arbitration, president of the ICC Africa Commission, Vice Chair of the IBA Arbitration Committee, and Director of Programs of the African Association of International Law. Earlier in her career, and of relevance to today's conference, she also spent some time at Bickel, working as a research assistant on that very prestigious project on damages in international investment law. Next, Doyin Rhodes-Vivour. Doyin is a senior advocate of Nigeria, British Chevening Scholar in the field of public international law and international relations, and a chartered arbitrator. She represents parties as counsel before the superior courts in Nigeria, as well as in international arbitrations, and also sits regularly as an arbitrator, being listed on various international arbitration panels. Doyin has held various leadership positions, including chairperson of the Nigeria branch of the Chartered Institute of Arbitrators, pioneer founding president of the Maritime Arbitrators Association of Nigeria, pioneer chairperson of the Nigeria Bar Association section on business law, arbitration and ADR committee, and pioneer chairperson of the ILA Nigeria branch arbitration committee. She's also a member of various international arbitration institutions and committees, including at the ICC, the LCIA, SIAC, and the PCA, as well as a committee very close to my own heart, the Global Steering Committee of the Equal Representation and Arbitration Pledge, where she co-chairs the African subcommittee. And last but not least, we have Matthew Weiniger, QC. Matthew is Global Co-Head of International Arbitration at Linklaters. He specializes in international arbitration and public international law with particular expertise in investment treaty arbitrations. He also regularly represents parties in arbitration-related proceedings before the English Commercial Court. Matthew has conducted numerous international arbitrations under most of the major arbitral rules in cases arising from all major industry sectors, in particular energy and financial services. Much of Matthew's experience has been gained in emerging markets, which of course includes Africa. So let me ask Ndanga then to kick off our panel with her presentation, which will focus on current themes and trends in substantive provisions of investment treaties and FTAs in Africa. I would first remind all of our panelists to please stick to their allotted 10 minutes, and I'm afraid I don't have such an elegant gong as Sir Bernard does, but I do reserve the right to ask Liam at Bickel to unceremoniously mute each panelist if they run over their allotted 10 minutes. So with that, I'll hand over to Ndanga.
Thank you very much, Sylvia, for that introduction. And I would also like to start by thanking the organizers for inviting me to speak and to share my thoughts on this important topic. And Sylvia, thank you very much actually for your excellent introduction of the topic, because you picked up on some of the themes that I wanted to introduce at the beginning of my presentation. So I'll just draw from some of what you've already said. And the first is that we're seeing this interest and energy focused on investor-state dispute settlement in Africa, and which has led to what some are calling the Africanization of rulemaking in international investment law in Africa. Now, this Africanization, so to speak, is this idea that African states want something else. And Professor Mbeng, who was in the previous panel, has written eloquently on this subject, so I won't repeat what he said. But it's this realization by African states and other stakeholders in investor-state arbitration in Africa that states do in fact have the tools and capacity to participate in international arbitration, whether it's with respect to arbitrators or with respect to the actual rulemaking and the substantive provisions. Now, the focus of this change in the rulemaking is on the rebalancing of rights between investors and states. And as Sylvia has already pointed out, this is not something that's unique to the African context, but it's particularly acute in the African context because here we see that most of the investors are non-African as opposed to other states where there may be a more balanced mix of investors. Now, again, as Sylvia already pointed out, this rebalancing is happening in a context in which not all African states are equal. And we see this indeed in the ways that African states have taken a stance on investor-state dispute settlement. Some are stridently opposed to it, especially with respect to the provisions on dispute resolution, and others have not stated a position. And this is to do with the acute need for investment in African states in order to foster development. So before I go to my remarks, I should state a caveat, which I always try to make when I speak about Africa, is we do oversimplify when we speak of trends and developments in Africa. I always think that we should do this with a map of Africa in front of us, showing us the geographical scale and showing us the diversity of peoples and laws and rules in order to really understand what we're talking about. But I will be following that trend of oversimplification for the purposes of discussion. And in my few minutes, I will look at three things. The first is to look at the levels at which these reforms are happening. The second is to look at some examples of the substance of these reforms. And the third is to say something about the African Continental Free Trade Agreement before I make some concluding remarks. Now, as to the levels of reform, we see that these are happening at several different levels: domestic, regional, bilateral, and continental. And the amount of work that's going into these reforms is enough to make any state official dizzy. We see reforms of investment agreements, we're seeing bilateral treaties being signed, and here in the last 5 years, we see African states have signed 48 bilateral investment treaties, only 6 of which are in force, 14 of which are with the United Arab Emirates, 12 with Turkey, which gives you a sense of where some of these investors are coming from, 5 from Brazil and 4 from Singapore. We see that there are 12 intra-Africa treaties, most of these signed by Morocco. At the regional level, we have this alphabet soup of acronyms for regional economic communities. We have the East African Community, COMESA, which is the Common Market for Eastern and Southern Africa. We have ECOWAS, the Economic Community of West African States, and all these regional economic communities are putting out instruments that are contain in them new forms of obligations for investors. And we also see examples of the SADC, which is the Southern African Development Community, Model BIT, and amendments to its Finance and Investment Protocol. At the continental level, we see that we have the Pan-African Investment Code, which was mentioned in the previous panel. And here we see what is an example of what some say could be the utopia of a BIT involving African states. Whether that is indeed a utopia is something that should be discussed, but the push for developing this instrument was this idea of something else. And while originally conceived as a binding instrument, it was ultimately adopted only as a guiding instrument. And we also see at the continental level, the African Continental Free Trade Agreement, which again was mentioned in the previous panel. And here the investment protocol is still a coming attraction. Now, what kind of reforms are we seeing in these instruments? Well, I'll mention 3. The first is with respect to clear statement of the need for investment to foster, promote, encourage sustainable development. And we see references to sustainable development in the preamble. We also see it as in the objective of the treaty, which is sometimes clearly stated as in the SADC model BIT, as that its purpose is to encourage and promote sustainable development, encourage investments that promote sustainable development. And we also see references to sustainable development with respect to other provisions, such as in connection with the CSR provision in the PAIC. We also see really advanced BIT, such as the Nigeria-Morocco BIT, which is celebrated, which contains multiple references to sustainable development. And yet, when we see other treaties signed by Morocco, we see that they don't contain any reference to sustainable development. So again, here we see this mismatch and this fragmentation in development of these reforms. And also nowhere do we see any definitions of what sustainable development is. So there is indeed a risk that it becomes one of these provisions which everybody agrees is a good thing and is important, but then loses its strength in the interpretation of its meaning when it comes to a dispute. Now, another provision that we see appearing is with respect to investor obligations. And here again, we see clear statements that are contained in these multiple levels of investment instruments. We see standalone chapters, such as in the PAIC. This is the Pan-African Investment Code. We see a standalone chapter in the ECOWAS Supplementary Act, and we also see other provisions, such as in the SADC model BIT, which make reference to rights and obligations of investors and states. And again, here, the idea is that this rebalancing is only achieved with this clear statement of what the obligations actually are. And finally, we have provisions on the right to regulate. Again, here, the link is made between the state's right to regulate under customary international law. So there's a recognition that that right exists. But the point here is that this has been one of the most fiercely debated topics in this reform or questions of reform or backlash even of investor-state dispute settlement. And here we're seeing that states and regional economic communities are putting into words this entitlement of the state to regulate. Now, moving quickly to the African Continental Free Trade Agreement, I wouldn't say much on this, it's already been discussed in the previous panel, but the important thing to note here is that this instrument, the investment protocol of the AFCFTA, presents an incredible opportunity, I should call it that, for states to articulate what they believe are the important provisions that should be contained in a Pan-African instrument, which achieve the objective of this rebalancing. Now, there are, the perception is that it will be based on the PAIC, which, as I mentioned before, has not been adopted universally as a binding instrument by African states. So there is a question that whether African states will actually accept the kind of obligations that have been articulated in the PIC in an investment protocol, which is currently being negotiated. And we can discuss more of that in the Q&A because there's much more to say. So I'll just park that there, but just to note that there's a question as to whether states will be able to agree on the actual provisions that go into that instrument. Now, in my last few seconds before I'm cut off, and I'm conscious of the time, just to make some concluding remarks of some of the things that we should be thinking about even as we celebrate this renewed energy on ISDS in Africa, is that what we're actually seeing from the instruments is that there is a discrepancy between the obligations that are contained in instruments that would apply to African investors and those that would apply to foreign investors. And here we're seeing that the obligations that would be borne by African investors would be higher, more ominous than those from foreign investors. And this is because of a combination of the new instruments that are Pan-African, that the regional economic communities are indeed African. And we can also glean some of that from the discrepancy between the BITs that are being signed intra-Africa and those that are being signed with non-African states. Something else that we should note,
Ndanga, you've gone on mute.
Yeah, I was muted by the host. I believe it's for my lack of discipline on time, but I will just say two more things on the conclusions, which just to open up for the discussion. And sorry about that. So the second thing the first thing is the discrepancy in obligations for investors. And the second thing is that there is a lack of coordination between the different levels at which reform is happening, which leaves states in a position where there's confusion about what they actually believe are the proper obligations that should be contained in these instruments. The third is that most African disputes in this field, in investor state, arise out of contract. So the question is, what is happening with respect to states having capacity to negotiate contracts that embody these visions or these ideas of this rebalancing? And the fourth point I was going to make is on the AFCFTA, which I've already made on the investment protocol. So I shall leave it there and apologize for my lack of discipline and look forward to the discussion. Thank you.
Thank you, Ndanga. And I'm very impressed that Liam took me at my word. Thank you, Liam. I'm sure we can talk about some of those subjects more during Q&A. There's lots of questions arising there and lots of interesting points that we could follow up on. But for now, I'll hand over to Doyin, who's going to discuss various challenges relating to investment treaties with reference to some relevant case law. Thank you, Doyin.
Okay, thank you. Thank you, Madam Chair, and I also thank the hosts for having me here today. Indeed, it's a pleasure to be here, and I also thank and appreciate my co-panelists. Okay, I have only 10 minutes, so let me get straight to the point. First of all, let me take it up from where Ndanga expressed that the objective is to encourage and promote sustainable development. And I think Africa has to bear that in close mind. They need to promote development. They need to improve the standard of living of the generality of the people. They need to improve the per capita income. And you can't do that without investment. So, but that does not mean that Africa is the only party to be considered in these investment treaties or the BITs or multilateral treaties. There are always two parties. So there's need to balance the interests of both sides. And both parties in entering into negotiations must bear this in mind at all times. I'm going to start off by illustrating areas of interest that need to be balanced and which pose to be challenges. Because when you have an investment dispute is all hovering around the area of balancing of interests. My interests aren't protected. I'm not being protected against taxation. I'm not being protected against tax reform. Your tax reform is contrary to the terms of the agreement you have entered into. You've expropriated my property. Those are all the areas you find around. So I'm just going to run through that. Policy areas. You have industrial policy. To what extent does the treaty allow the domestic market to also thrive? To what extent does it engender confidence or lack of confidence by the generality of the people? And then that starts a lot of hue and cry against those investment treaties. To what extent are your tax reforms in compliance with the treaties? And I'll mention a couple of cases, like the Total AMP Uganda versus Uganda case. That was based on stamp duty, which was imposed by the Ugandan Revenue Authority. And the investor considered itself entitled to a tax waiver by virtue of its contract with the government of Uganda. You can see both objective seems fair enough. So how do you balance that? The use of capital controls. The investor wants to be able to take his money out. The host country wants to protect his money. It puts in regulations, all kinds of laws, which appears to affect the ability of the investor to take its money out. IP rights, intellectual property, public-private partnerships, and perceived threats to domestic sovereignty and weakening of the rule of law. That's also very important because you find that many host countries begin to feel that they cannot even make laws anymore because of these treaties that they have entered into. At that point in time, that overshadows the real purpose of entering into that treaty, which is to raise income for the country, to raise the standard of living of its people, to aid its development. And an example of that is the Piero Foresti case. It was an ICSID case which arose from South Africa's legislative enactment of the Mineral and Petroleum Development. The investor considered that expropriation, and that was the case that led, or maybe part of the reasons that led to South Africa's reaction to the investment treaty arbitration world. And in that respect, a statement made by, in respect of the Philip Morris case comes to mind, where it was stated that investor state dispute settlement by a writer has been accused of being a system that threatens domestic sovereignty by empowering foreign corporations to bypass the domestic court systems and weaken the rule of law. I mean, that's not good for a relationship between either the host state and the investor. Then there's a perceived infringement of the host right to manage its natural resources. Even the people begin to agitate. Why can't we manage our own natural resources? Why can't we be in charge of our natural resources? And that sort of undermines the purpose of the investment and the treaty that has been entered into. Transparency. How transparent is investment arbitration? And that's why we had reform had to come in that area. You have now the transparency rules. There's more reform in that area because it's now widely acknowledged that the people of a nation have a right to information about what happens in those type of cases as distinct from purely commercial cases where there's a lot of confidentiality. Then perceived abuse of treaty rights. We have some cases on that too. We have the Orascom TMT Investments versus Democratic Republic of Algeria. We have the Capital Financial Holdings Luxembourg versus Republic of Cameroon. And one of those cases touched on 3 different arbitrations that were instituted that touched on the same type of subject matter. And that was perceived as an abuse of treaty rights. And in that case, the arbitral tribunal upheld that. And then let's look now, just to summarize and not take too much time, I would like to be cut off, about what is the interest of the investor. The interest of the investor is capital repatriation. He wants to repatriate his money. Capital, and then expropriation. He doesn't want his property taken. That has also led to a number of cases, including Capital Financial Holdings versus Cameroon, Ample American and others versus Arab Republic of Egypt, which is an Egyptian case. As was mentioned in the other panel, Egypt does have a lot of cases, unlike Nigeria, but they do have a lot of cases. And that has also set off the climate for the reforms they are also bringing into the investment arbitration field as it affects Egypt. Then you have another key area, dispute resolution in the courts of the host country. Investors don't want to have that. Investors want a neutral ground for resolving the disputes that arise. About security concerns, that was an issue that came up in Ample America and others versus Egypt, when the investors felt they had not had enough protection against terrorist action. And in that case, I believe the arbitral tribunal upheld their position. Then, of course, taxation. Taxation. The respondent state in Apple America was found to have also taken measures that amount to withdraw the tax-free status that had been granted or accorded to the investor. There are various other cases as well. And all these are the things that brings to mind the need that these interests have to be balanced. If the investment arbitration world is to retain its legitimacy or begin to build up some form of legitimacy again. In the arbitration, in the dispute resolution field, we had the earlier panel that talked about diversity. Do Africans appoint their peers to investment tribunals? Are there African councils on those tribunals? And there's no matter how we try to ignore the subject, but diversity has a lot to do with legitimacy of those decisions that come out. Because when you have a panel over a dispute that concerns an African state, and all the panelists, all the arbitral tribunal members, there's no one from Africa, it begins to raise the issue of legitimacy. And I looked through a number of cases and I found that even if you don't appoint Americans, there's a particular case where the respondent appointed somebody from Egypt. No, sorry, it was an Egyptian case actually, appointed an American. And you hardly find any Africans on those panels. Maybe things are getting better now. There's a low appointment of African arbitrators and counsel. That is also a balancing issue, because until those areas are also resolved, Africans will still continue to feel that the investment arbitration world has not been fair to them. Challenging the arbitrator, alleged bias. How about issue-based conflicts? How about double hatting, where an arbitrator is arbitrator in one matter and then is counsel in another matter that affect the same type of issues? How fair is that to the arbitral system? Thankfully that I believe action is also being taken on that by the work of Institutional Working Group 3. Perception that the international arbitration world is controlled by a small and close-knit group of people, not from Africa. That also raises issues of balancing of interests. Then the cost of dispute resolution. How expensive is it for African countries? Those are all the areas that are raising concerns, and African countries are beginning to have a shift from the traditional types of BITs and investment treaties, enforcement issues, length of time. Now, what has been the effect of these challenges is another area I'd like to touch on. Basically, when people are not satisfied, they will take action of their own. We saw South Africa withdrew from the system. Bolivia, Ecuador, Venezuela, India, Brazil, they all withdrew from exit arbitration. Then in September 2018, Tanzania also decided it was going to put an end to the existing bilateral investment treaties. that are all issues that indicate that all is not well with the system. New bids are now being signed with a more balanced approach. The Nigeria-Morocco Treaty is one that always comes to mind. It has provisions on corporate social responsibility, on labor, on so many areas that, on human rights, so many areas that were not being accorded attention in those treaties before. But things are changing because there's a lot of discontent. Another thing they've done in the Morocco-Nigeria BIT is this concept of cost, to deal with the concept of cost. We all know how costs can be in international arbitration, particularly even investment arbitration. There's a provision in the Morocco-Nigeria BIT that removes the provision or removes the conception that the loser must pay all. In that BIT, each party bears its own costs. And some other measures that could be taken by an arbitral tribunal were also prohibited in that BIT. That only goes to show that African states are beginning to take action. Maybe 40 years ago, African states did not know much about how to negotiate contracts. But I'll say that the United Nations has played a very useful role, because I'll say something that there was a time they were coming into Nigeria, and through the Ministry of Justice, they were training arbitrators in Nigeria. I'm a beneficiary of that as far back as 1980, when I was still a little state counsel in the Ministry of Justice. They trained arbitrators, so we have the expertise in Nigeria. We have capacity building in Nigeria. We have African arbitrators, and I meet African arbitrators all over the world when I go on my conference, and I know we have the capability. So the institutions should begin to do more to redress the system, because if they don't redress the system, this lack of balancing will create a problem whereby there'll be more mistrust amongst the players. And Africans need investment. The investors also need their money, but both must be balanced. Ndanga has spoken about the investment chapter of the ACFTA, so I will not go into that. I've mentioned that the ICSID and UNCITRAL have a draft code for adjudicators in investment arbitration disputes to curb this issue of double hatting. In conclusion, I don't know how many more minutes I have before
you have zero, Doyin.
I have zero. Okay, so let me just go to conclusion, right? Foreign direct investment is crucial for African countries dealing with the need to eradicate poverty and raise the standard of living of the majority of its people. We do need foreign direct investment. We should also begin to look inwards towards ways of utilizing our natural resources in the best possible way. What are we doing about agriculture? What are we doing about our land, our weather that favors agriculture? What are we doing to make income? What are we doing to make ourselves self-sufficient? It's hopefully the new free trade area agreement will kick in some benefits for African countries as a whole. We have to also ensure that the landscape of investment treaty does not continue to engender mistrust between developing countries and the host countries. It should be a symbiotic relationship. We do all both need each other, but the challenges are there. And reform should be effected to balance the promotion of investment, the protection of the investor, the protection of the host, and the consent of the host state. Great attention must be placed on having disputes settled by that. May I also mention, sorry, Sylvia, that even in the Morocco BIT Treaty, there's now greater emphasis to have disputes settled through our traditional means of dispute resolution, mediation, conciliation, before stepping into arbitration. That should be the way forward. There should be greater concern on having disputes settled by a diverse group of experienced dispute resolvers. Africa has that. The Western world also has that. So let's all work together, inclusive of a large and available pool of experienced and seasoned African international arbitrators. Any concerns by African states for domestic recourse prior to resolution by an international forum can only be addressed should African countries ensure that their judiciary is strong and independent. That's also a crucial issue for African countries to bear in mind. Strong and independent judiciary with a reputation for expeditious dispute settlement. Thank you very much.
Thank you, Doyin, very much for that very interesting presentation. I will now turn to Matthew, who is going to overlay one topical issue on another topical issue and talk to us about investment treaty claims that may arise from the current COVID-19 crisis. Thank you, Matthew.
Thank you, Sylvia, and thank you, Bickel, for this invitation. Sylvia, can you hear me? Just want to clarify.
I can hear you perfectly.
Perfect. Okay, I had some technological issues logging in, but that's great. So my topic is going to be investment arbitration and COVID-19, to bring the two subjects together. Not being an African and not having anything like the African expertise of my fellow panel members, I thought it more appropriate for me to talk about something of global importance, but obviously something that is relevant to Africa as well. And I'm going to look at this from three areas. Firstly, the sort of measures that states have taken around COVID-19. Secondly, the ways in which those measures could give rise to claims from investors. And thirdly, the sort of defences that states, whether African or otherwise, could raise to those claims. Because there have been lots of discussions about whether various governmental actions could give rise to this sort of investment treaty claim. So let's look at some of the things that have happened around the world, not just in Africa. Some states have allowed final users not to pay their electricity bills, for example, but at the same time have compelled the providers of those utility services to continue to provide those services. There's no ability to reclaim penalty costs or no ability to reclaim interest. So this suspension of payments has amounted to a freezing of the investors' rights, who have in many circumstances put a lot of money into improving the utility network. And a similar example is in one country where there's been a suspension of the collection of toll fees on a road network that an investor has built. Other state actions: compelling production. Some countries have ordered manufacturers to provide thousands of ventilators for the treatment of COVID-19. And similarly, the race to produce a vaccine may also lead to the nationalization of production lines. Another category of state actions is the seizure of private property. Some states have seen large, well-maintained stockpiles of hospital masks and other personal protective equipment, and have seized those by requisition orders for use in state-run hospitals, and in fact the seizure of non-state-run hospitals. So private investors who have hospitals have found that they've been compelled to hand over the facilities for state uses. In a similar vein, price regulation. So investors who have been allowed to still sell and use their stockpiles of various medical equipment have found that the price at which they can use those equipment has been limited. And also a number of measures with indirect impacts, whereby non-essential businesses in many countries in the world have been closed by governmental decree for extensive periods of time. And those are the specific actions. There's also a number of general actions whereby some states have, the government has appropriated to itself the right to rule by decree without the need for any parliamentary or judicial oversight. So those are some of the measures that have been taken by states in these extraordinary circumstances. And a number of commentators have said that these sorts of measures could give rise to claims. So what sorts of claims could arise? Well, the first claim is under the fair and equitable treatment standard. And obviously, this is the first place that investors often look, because the fair and equitable treatment standard is a very flexible standard. And this will depend, and whether or not a claim can be brought against this standard will depend on whether the restrictions have been imposed openly and fairly. Governmental regulations have to be proportional to the risk, and whereas some coronavirus business restrictions are often longer than necessary or have been broader in scope than necessary, and this could give rise to a potential FET claim. Similarly, if unreasonable penalties exist, and that could also give rise to an FET claim. And the other thing to bear in mind is that if the COVID-19 restrictions specifically contradict any guarantees or assurances made to foreign investors, particularly in investment contracts, then that could give rise to claims. So that's FET. Also, there are the possibility of expropriation claims, because while brief seizures of properties are permitted in emergency situations, there have been previous cases where seizures that last even less than a year have been considered to be an expropriation. So a temporary seizure in certain circumstances can give rise to an investment claim, and a tribunal assessing this issue would need to look at the duration of the seizure, and also obviously any compensation that is paid to a foreign investor in return for taking their property. Other claims would come under national treatment, and where there'd be a need to consider whether the COVID-19 restrictions have been imposed in a discriminatory manner. If these restrictions are only placed on foreign investors, or if they're only placed on investors from specific countries, then a discrimination claim could arise. And in the same way, there have been previously national treatment claims that have arisen where bailouts have been made, and bailouts that have only applied to certain sectors or certain manufacturers within a sector, that can give rise to national treatment claims. And finally, the final sort of claim that could arise is under the full protection and security standard, where an investor says that the way that the health crisis has been handled has breached the obligation of a country to afford full protection and security. So that's a brief outline of the sort of claims that could arise. What defences could states assert? Well, there are three main sources of defences that states could assert under investment treaties. The first type of defence are those based specifically in treaties themselves. And some investment agreements, in particular the more modern ones, as Ndanga was explaining, actually set out express exceptions or carve-outs. So the treaties are the benefit of, the treaty parties have taken the benefit of what's happened previously in investment arbitrations to work out what sort of defences should specifically be included in the treaties. And an example of this is the CETA provision that's in the treaty between Canada and the European Union, where a carve-out is made in the expropriation provision. And there, the states have said that as long as an impact of a measure is not excessive and it's not discriminatory, then any measures that's designed to protect legitimate public welfare objectives such as health, safety and the environment will not constitute indirect expropriations. And that CETA provision has now been commonly replicated in many other modern investment treaties. So there's the treaty exceptions and defences. The second level of defence is the customary international law defences. The ILC, the International Law Commission articles on state responsibility, lists 6 specific defences that states can raise when faced with a claim: consent, self-defense, countermeasures, force majeure, distress, and necessity. And of those 6, obviously necessity, force majeure, and distress would be the most relevant in relation to the COVID-19 crisis. Each state measure for which a defence is invoked will obviously be analysed separately, and there'll be a need to take into account the nature of the measure, its purpose, its timing, its scope, and duration. The final source of defences will be under the police powers doctrine. States, as a general matter of public international law, are afforded broad, what's known as police powers to regulate in the public interest. And the protection of public health is obviously one of those matters of the public interest. And this is a matter that's arisen in many investment arbitrations, and indeed in international disputes preceding investment arbitration. There is the famous Bischoff case, at the turn of the 20th century, when the Venezuelan authorities seized a German horse and carriage during a smallpox epidemic. they believed that this carriage was coming into Venezuela and was infected and could be a vector of disease. It was mistaken, as it turned out, but this famous decision of a mixed claims commission gave rise and set out in words the idea of police powers, including health provisions, and such and police powers have also been invoked in recent investment arbitrations, such as Methanex in the United States, which is a case about a state's ban of a fuel additive that was harmful to public health, or a more recent Canadian case, Chemtura and Canada, which was about an agricultural insecticide. And perhaps the most famous use of this police powers doctrine is in the Philip Morris and Uruguay case, where Uruguay succeeded in defending a claim arising out of its tobacco regulations, saying that the tribunal held that a measure protecting public health, as obviously tobacco regulation would be, was an essential manifestation of the state's police powers. Now, in this presentation, I've tried to be balanced and provide both sides, the claim side and the defense side. Police powers, like all of the other things here, are not unfettered. Everything must be non-discriminatory and proportionate. So what I've tried to do here is really to set out the parameters of the debate, because many people look at state measures and say, oh, well, that definitely infringes investment treaty rights. Or they say, well, there's no way that you could infringe investment treaty rights if something is done to protect public health. The debate within the framework of properly informed investment treaty regulation needs to be more subtle than that. And I hope that I've given some introduction to how the debate could possibly be framed. Thank you.
Thank you, Matthew, for that very well balanced presentation on that particular topic. I would invite the audience members, please, to submit questions on the Q&A. I can see we've had one specific question on this session, plus one from an earlier session that are both relevant, both excellent questions. But I'll start, if I may, with Ben Sanderson's question, which I will direct originally to Ndanga, but obviously can be answered by anyone on the panel. And Liam, will you promote Ben so that he can ask his question? Could I ask Ben, before you ask your question, if you can just introduce yourself for the benefit of the panelists, that would be great.
Of course. Thank you, Sylvia. I'm Ben Sanderson, Global Practice Manager for International Arbitration at DLA Piper. My question picks up on something that Ndanga was saying earlier, which is about the efforts by African states to negotiate on a continental-wide basis currently between themselves, and really whether those efforts are slightly misplaced, and whether African states ought to be negotiating either as a regional bloc or as a continental bloc vis-a-vis non-African states in order to remedy what are seen as the deficiencies in the old school investment treaties that are currently in place.
Thank you very much, Ben. Nice to see you, and thank you very much for that question. My first reaction to the question is that I would push back against any suggestion that African states are spending too much energy. I think sovereign states must be allowed to define what they set as their priorities. And I think, as Ambassador Negm said in an earlier session, that this is an important development for African states to come together in this way. So I think African states must, in the first instance, be at liberty to set what their priorities are. Now, but that's not an unqualified response. My concern with the efforts that are being spent in this continental effort is one of capacity. So there is, of course, low capacity in Africa in this area, and any energy that's spent on a continental at a continental level means that domestic concerns and more regional and bilateral concerns or efforts are sort of retarded or delayed or neglected. So there is that question of prioritization is, in the first instance, should states be spending more time internally reflecting on what the organization of their investment treaties and obligations and so forth are before attempting to negotiate at a continental level without a full understanding of their own rights and obligations as they exist. So that's the qualification to my states must do as they wish. And with respect to the question of whether they should negotiate as a bloc, it's tempting and it's attractive because, of course, with 54 states of different strengths, you might get a better deal, so to speak, as ECOWAS than if you attempt to go as Benin. But the reality is that we don't have the kind of economic integration that would make that kind of negotiation meaningful. So we can get broad themes, but we're not going to get an instance where you get really meaningful negotiations with these blocks with a counterparty as a foreign state, because the reality is we don't have that economic integration. I hope that answers your question somewhat.
If I may ask a follow-up question while we're on the topic of the African Continental Free Trade Agreement. You mentioned the investment protocol, and obviously you didn't have a huge amount of time to go into that in detail, but it's a very ambitious project. Could you say a few words about that project and what some of the challenges might be in terms of getting that up and running?
Yeah, I think the problems that we'll see with the investment protocol are the same that we've seen with the Pan-African Investment Code, is in getting agreement across the continent with states with really quite diverse needs and perspectives on a cross-border investment. And so agreeing on an investment protocol which is aimed at intra-Africa trade with African investors is going to be quite difficult. And if the starting point is the kinds of obligations that we've seen in the PIAC, which is the discussion that's being had at the moment, although we don't actually really know what's going on in the negotiations, those are not transparent. But I see the same problems that we had with the PIAC when you have states such as South Africa, economic powerhouse, dominant in trade in Southern Africa, which is opposed to ISDS, for example, and is opposed to broad rights for investors. So it is looking at constricting the rights of investors, while other states, which might have more need for foreign investment, might be looking at more opening up. And also the reality is that this protocol is being negotiated in a context where we don't have that much intra-Africa investment. So it's quite difficult to build a profile of intra-Africa investors if we're using a model that's based on investors, which I think is what we're doing, based on investors who are European, American, and Asian investors. And that doesn't quite translate. So that's why we're seeing that the kind of language that's being used might be terrific in an instance where you have a Western investor or an American investor, but where you're sitting in a context where you're actually trying to promote cross-border trade within the continent, those might be too restrictive. So all of that to say that I see problems with agreement amongst states on what those provisions will look like. And I see also problems with defining content that actually achieves the objectives that the investment protocol sets out to achieve.
Let me perhaps follow up on Ben's question with a question for all of the panel. And this is this sense of whether Africa is too inward-looking currently rather than outward-looking. And I go back to my point about the backlash against ISDS being a global phenomenon. Of course, we're seeing many attempts to reform the international system, including the Untitled Working Group 3. And I was interested in any of the panel's views on whether African states, not necessarily as a bloc, because I completely appreciate Ndanga's point that it is impossible to negotiate as a bloc, but individually, those who have had more experience of ISDS, whether they should be doing more on the global stage to have their voices heard in the current global debate about ISDS. I'll admit that I took a quick peek last night on Untitled Working Group 3's website and the last meetings that were held to see if any submissions had been made. And I noticed that South Africa and Morocco made submissions on the last round, but I don't know if any of the panelists are familiar with any of the prior submissions or any other outreaches or initiatives by African states on the global sphere.
I think Matthew was going to say something, and I can speak after him. I don't want to dominate the questions.
Well, it's not for me to really criticize or otherwise the efforts made by African states, but I think there are certainly individuals in Africa who make their names, who make their voices known, and you know, my career in arbitration over the last 25 years or so, one of the most notable features is the number of voices that are now heard from states, not just in Africa, which were excluded from the arbitration debate. The arbitration world has opened up, and it's fantastic that that door that has been opened, many highly qualified people are climbing through. And there are some specific African contributions. One of the new Moroccan investment treaties is actually very far-sighted in the way that it seeks to deal with incorporation of the sort of things that you and Ndanga was talking about, the CSR and the human rights thing. And that is something that I know from discussing investment treaties with governments around the world, is something that's often held up and often discussed, the new Moroccan approach to treaty drafting. So that is an example of something that's coming from Africa that is having global impact.
And just to pick up on that, Sylvia, with respect to the submissions that we've seen at ANCITRA Working Group 3, and I've attended some of the sessions, is we've seen 3 submissions. The first is from South Africa, and the content is no surprise. South Africa wants to get rid of the system, and it articulates that, I think, quite strongly in the submissions that it makes, which is consistent with its own internal policy, and thinks that the focus of this kind of balance between investor and states' rights should be elsewhere, more domestic, much more focused on sustainable development. We also see a submission from Morocco, and as Matthew says, again reflects Morocco's energy, I guess, in really looking inward and drafting a model BIT which articulates this rebalancing and states its position on investor-state arbitration or dispute settlement. But also we see the difficulties with that when we look at the treaties that Morocco has signed with other states, for example, in the last 5 years with Japan and Rwanda, which, for example, don't make any reference to sustainable development and don't show evidence of this new thinking on investor-state dispute settlement. So that's an aside on Morocco. And the third, which we see, which is interesting, is Mali. Now, again, Mali's submission reflects its own position as a state that's dependent a lot on foreign investment. And what Mali says is that there needs to be a drafting of treaties which reflect this imbalance between states that are always recipients of foreign investment and states that may sometimes be exporters of investors. And so with these 3 different states, we see voicing of these very particular and different concerns at the global stage. But again, we see the challenge in getting a continent-wide coherence in ISDS, or an approach to ISDS. Now, with respect to participation, and I'll just touch on that quickly, we've seen a dramatic increase in the number of African states that actually attend ANCITRA Working Group 3. So from the very first session, I think it was 2017, handful of states, to much more recently in the extra session in January this year, where we saw many more states, not necessarily all participating actively, but they're present in the room, which is, I think, a lot of progress. And we've also seen, as we heard from Ambassador earlier on, the participation of the AU in the last 2 sessions, which I think reflects this change from observing from a distance to actually being present, and perhaps even translating that to actual coordination of positions by African states, as the ambassador intimated earlier. I'll stop there.
Thank you, Ndanga. I can see that Liam has promoted both Bankole and Jarek, who each have questions. So maybe we'll start with Bankole first.
Okay. Yes. I'd like your comment. What do you think about the possibility of having an African-wide model agreement that African nations may seek to adopt in negotiating and drafting BITs going forward?
Go ahead, Doyin. You can unmute, please. Doyin, you're still on mute. If you just unmute, we'll be able to hear you. Try now.
Yes, I am. So I think that's a good idea, because if African countries can get together and really work together what is their interest and what they want to get from these BITs, and they have a standard form, something like the standard form format, of course, which can always be tweaked where necessary, then it makes it clear to the countries they are trading with or the countries they're entering into those agreements with that they're not going to get any better or worse terms from entering into those treaties. And I think it gives some strength to African countries when they are negotiating their own individual agreements. So that's why I think it's quite a good idea. They can all get together and work together. I mean, there are advantages to coming together as a bloc. It gives you a stronger negotiating strength. It makes your voice better heard. So if that could be possible, I don't see why that should be difficult if they can all enter into this free trade agreement. I think that should be one of their objectives. Yeah.
Thank you, Doyin. Jarek, did you want to ask your question?
Yes. I was wondering what makes Africa-related disputes, in particular investor-state disputes, different from disputes arising out of other regions. And I know that all of you have experience dealing with Africa-related disputes, and some, if not all of you, also have experience dealing with disputes from other regions. And Sylvia, although you are the head of African disputes at Freshfields, you also do plenty of Latin American disputes and so on. And Matthew is also doing various cases. Could you share your observations, what makes them different, not only in terms of applicable law or applicable rules, but perhaps also the way how lawyers work, or how arbitrators work, or logistical issues? Thank you.
Jarek, I'm taking from your question that you have now promoted me from chair to panelist, and I'll take the liberty of answering first, if I may.
Yes, please.
It's a very interesting question, and one I have thought about a lot, having spent a decade doing investment treaty disputes in Latin America and then a decade doing them in Africa. I will make two observations and keep them short. One, I think Ndanga mentioned earlier, is there's a prevalence of contractual disputes on the investor-state front in Africa that there wasn't in Latin America, for example. The good old Calvo clause in Latin America ensured that local contracts didn't provide for international arbitration and the disputes had to be brought under treaties. That has not been the case in Africa. Some African jurisdictions do, especially now, have a preference for local arbitration clauses, but there was a long time during which several very important African states included international arbitration clauses in their contracts, including exit clauses, but often seats abroad. And we've seen a lot of those cases. So many of the ones that I have done have been contract rather than treaty, and that has been a real difference. Take Nigeria, for example. A lot of the disputes that are well known in the Nigerian oil sector have been contract disputes. And in fact, there's only been one treaty dispute against Nigeria, which is a very small amount given the amount of foreign investment in Nigeria. The other point I would make about African disputes is that in my experience, investors have been more reluctant to go nuclear, as they put it, pull the trigger on investor-state disputes, and then very, very keen to settle them. So a lot of my African disputes have settled in a way that in Latin America, we really saw them go the whole hog. And I won't profess to understand why that is. I think others perhaps may have an even better view than me, but I'll pause there and hand over to Matthew and then others.
Okay, thank you, Sylvia. I would actually say that there's more similarities between disputes, investor-state disputes, wherever they arise in the world, than differences. So you have to look a little bit hard to find specific African features. And some of the features, the most notable things about African disputes are more symptoms of the economies of many African countries. So a lot of the African investment disputes are infrastructure or concession agreement disputes, rather than things that that affect the relationship between customers and businesses more. I'm thinking of the you know, in Spain, you've got the solar tariff cases, and you've got water tariff cases in many countries around the world, whereas many of these situations in Africa relate to things that are not functioning systems, but systems that are still being built, and so it's an earlier stage of the project dispute. And then other, you know, general frustrations with things as they happen in Africa, and you cannot always move as quickly in many African countries as Western arbitrators demand. I remember a disclosure order which was made against an African state. The state would have liked to comply, but due to power cuts in the place where the only photocopier in town was, there was no way that the documents could be collected and scanned and uploaded in a way that would have happened in a more developed state. So, but again, that's not necessarily solely an African issue. It happens around the world in disputes arising out of more impoverished states.
Dorian, I can see that you're unmuted. Did you want to go next?
Okay. That was the question on. That was the question. Well, I'll take what Sylvia. I'll start from Sylvia's point about the number of BIT disputes that Nigeria has had, and she notes that it's only one, which is a fact, considering the level of investment in Nigeria and really big investment, particularly in the oil and gas. And I think there are various reasons for that. I think first of all, we have to consider how many of those treaties that Nigeria has entered into are actually in force. And then we also have to look at even the ones that are in force. How many investors from those countries that have investment treaties in force are actually doing business in Nigeria? And then we also find that Nigeria over the years has developed a policy anyway with respect to dispute resolution. I believe the local content law says all disputes must be resolved in the oil and gas industry, must be resolved in Nigeria. So that would even affect that as well. Because even if you have an investment treaty and the investor wants to come, he doesn't want to ruin his relationship in the whole state, and he knows its policies, then he'll try to an extent to comply. So apart from that, I also think that a lot of the disputes concerning investors have agreements that they have signed, where they've either agreed to an LCIA arbitration, an ICC arbitration, or an ad hoc arbitration. So we find that our statistics are more or less higher on those stakes than having a resolution under ICSID or any of the provisions of BITs. So I think I'd like to add that. But one thing I also wanted to add to what we're discussing about the free trade zone is, to what extent do we consider that the level of infrastructure in Africa, as well as interconnectivity within African states, to what extent will it impact on really achieving the goals of the free area agreement? It's just a point that I have pondered about. I'll unmute myself now.
Thank you, Diane. Ndanga, did you want to answer Yarek's question?
No, I think you've all done a superb job, so I dare not add anything to that. Thank you.
Very good. We have, I can't see the question, but I can see that Liam has promoted Evalio Dimitrov. So Evalio, would you like to ask your question?
Just to check, am I audible? Can you hear me?
You are indeed.
Great. Well, thank you very much. Evalio Dimitrov from Omnia Strategy London. And good afternoon to everyone, and thank you for this excellent discussion. I was just wondering, and the panelists already mentioned some of the regional instruments, meaning the SADC protocol and the ECWA Supplementary Act on Investments. And I completely echo the comments that these includes some very creative and innovative options that are trying to tackle with, the backlash on ISDS system being one-sided. And these were already mentioned. I mean, the business to human rights aspects, the obligations on investors, the specific reference to sustainable development. But we don't see these regional instruments in use, at least in the public domain. From my recollection, I only remember one case that is in the public domain, that is Swissboro versus Lesotho under the SADC protocol, if I'm not mistaken. So I was just wondering, what do you think are the underlying reasons why these instruments are not being used? And do you think that this can change in the future? One of the reasons that was mentioned is perhaps the lack of intra-African portfolio of investors. And, I'll just mute myself and I will leave the panelists now to answer that question if possible.
Thank you.
Actually have.
Go ahead, Matthew.
Well, I think these have been used more than people would know, and particularly just because you don't see a dispute registered at ICSID or any other institution doesn't mean that these instruments are not of practical use. And as Sylvia was saying, many African disputes actually do settle, and part of that settlement is a discussion in which the investors talk about their rights under legal instruments, including SADC and these other instruments that are in your question. So I think they are used, just not necessarily in as public a forum as other instruments.
And just to add on to what Matthew has said, is that some of the greatest innovations that we see are in instruments that are either not in force or that are simply guidance documents, such as the SADC BIT, Model BIT, the East African Community Model BIT. And what these are supposed to do is to inspire member states in their own negotiations with third states. So we would need to see, to answer your question, these states adopting those instruments in their own negotiations, and at least some of the provisions in them. But I think you also answered your own question by saying perhaps we would need to see more intra-Africa investment in order to see these instruments come alive.
Thank you. And with that, I see we're at 1:41. I think 1 minute over time is just about acceptable. I haven't been cut off yet, but I'm probably about to be. All that's left for me to do is to thank first and foremost the panelists for a really interesting, stimulating and thought-provoking discussion. Thank you. Thanks again to our organisers today, Bickel, Queen Mary and Babcock University. And thanks to Liam for facilitating the technology quite so seamlessly. I'll now hand over to Jarek, who I think is, together with Bankole, going to draw a close to today's proceedings. Thank you all.
Thank you very much, Sylvia, for your moderation, and all panelists for their excellent presentations. And now Bankole will spend a few minutes summarizing the day with a few remarks of his own. And I will see you tomorrow morning. Thank you.
On behalf of Bickel, the School of International Arbitration at Queen Mary and Babcock University, we want to thank our keynote speaker, the Honorable Attorney General of Nigeria and Minister of Justice, Mr. Malami, Senior Advocate of Nigeria, for his incisive discourse. And we hope to be able to engage him even on some of the issues that he has raised. I want to thank the moderators, Sir Bernard and Sylvia Noury, and of course, our panelists who have worked tirelessly to present complex issues in a short but easily understood manner. Our objective has been to ignite a series of engagements in the arbitration space in Africa. One of the aims is to offer support and assistance to government entities and private organizations for capacity building, whether in the review, negotiation, or drafting of investment treaties, court rules, regulations, and so on that can enhance the use and enforcement of arbitration in Africa. And that's why the group of star-studded panelists that we've brought together have helped. And we are going to continue this engagement because to do this, we will need to surmount the challenge of lack of reliable data in Africa. In some parts of Africa where there is some data, the data is not necessarily subjected to critical analysis. And so we would like to be able to collaborate with African institutions and parties in conducting studies and obtaining data in the ADR space. For instance, it will be interesting to analyze the data emanating from African courts, multi-door institutions, or the issues that could make South Africa, Tanzania, and some of the nations we've mentioned today, who are beginning to have or develop a bias against BITs, to re-embrace investment treaties. Some of the studies may showcase Africa to the rest of the world, and perhaps maybe the rest of the world may learn from Africa, because indeed traditional African societies are so used to dispute resolution mechanisms that are similar to ADR. We would like to conduct studies to review court cases that suggest the attitude of African states to arbitration. Sometimes people have not been fair to African states because one or two decisions of courts, so they say it suggests that those states or those countries are not arbitration friendly. But if you really scrutinize under academic spotlight, you find out that there are ways out, and that is part of why we are collaborating on this. So there is opportunity for sponsorship of some of these studies, and we also hope that we will also go into publications. We're considering even a journal. So we are hoping to push the frontiers of arbitration in Africa, and we look forward to having you tomorrow, even as we feature another star-studded cast of arbitrators on the same topic, as we do the next round of our first and inaugural Gandhi conference, arbitration conference. Thank you very much.